just me briefly. My name is Raissa. I am the New South Wales Outreach lawyer here at the Hume Riverina Community Legal Service. I guess if any of you wanted to, you could sort of unmute and introduce yourself and tell us a little bit about yourselves. If not, that's completely fine. We can get straight into the presentation if you'd prefer.
I think most of us know each other.
Okay.
I'm just having a quick look. I can see that I'm going to put them on the spot, but it's up to them. I can see that Colleen and Bessie from Mission are with us if they wanted to introduce themselves or maybe pop something in the chat. But I think for the most part, most of us know each other.
Okay. All right. Well, if you're happy for me to just start the presentation, I am going to be a little bit rude and turn my camera off just so that I can manage any chats or admit people as well as running the presentation because I'm not particularly good at doing all of that. So let me just see here. Do that. Windows. Let's see if this works. Okay, can you all see the presentation?
Yep.
Okay, all right. Now I'm going to come back here, turn the camera off, but you can all still see the presentation and it's full screen. All right, perfect. Okay, I'll just put my glasses on so I can actually see things. Okay, so just a brief background on today's session is going to be on housing. We're going to look at the legal fixes to tenancy problems, and also at the end we'll have a brief look at domestic violence and some common issues that come up regarding loans and debts. So I would like to acknowledge the traditional owners and the land on which we work and pay our respects to their elders past and present. As people working in the legal system, we can't ignore the discrimination and disadvantage that Aboriginal and Torres Strait Islander people, families and communities have and continue to face in our legal system. Our work to achieve our vision of a just society must come from a foundation that values and respects the knowledge and teaching forever embedded within the Aboriginal custodianship of this country. Okay, so I think I just heard someone.
Oh, I've just been admitting people. I hope that's okay, so you don't have to worry about it.
If you're able to do that, thank you.
Fine.
That's a massive help. Thank you. Okay, so this is our disclaimer slide. So the information provided today is general legal information only. It's not legal advice and is not to be relied upon when you are dealing with clients. So every set of circumstances does need to be looked at individually, and legal advice must be obtained only if there is a legal problem. So as lawyers, we generally do require comprehensive and sufficient instructions before we can give any advice. Okay. So who we are, so we are trained qualified lawyers and we are dedicated to helping those who may not be able to afford or pay for legal advice or have access to justice. So we as a service really firmly believe that access to justice should be accessible to everybody, not just those who can afford it. So our service is independent. We come under the auspice of Upper Murray Family Care. We are not part of the government or legal aid. We are non-profit. All of our services are free. However, we do rely on government funding, grants and donations in order to provide these services to the community. So our services are available to people on both sides of the border. We are the only free legal advice service within a 2-hour radius, and we do service 17 council areas within both New South Wales and Victoria. And we have New South Wales and Victorian outreach lawyers who are committed to helping people grapple with cross-border issues and potentially different legislation. Okay, so just a bit of an overview of today's session. So we're going to discuss the Residential Tenancies Act, tenants' rights and obligation, landlords' obligations in relation to repairs, rental arrears, options for dealing with them, evictions, what rights tenants might have, options available to tenants who are victims of domestic violence, and also impacts of domestic violence in regards to debts and loans. Okay, and just at any point, if you want to jump in, if you've got a question or anything, just unmute yourself and ask. Okay, all right, so let's delve into the Residential Tenancies Act. So it is the main piece of legislation which deals with tenancies in New South Wales. Most residential tenancies are covered by the Act with the exemption of residential aged care, respite, care premises, serviced apartments, boarding and lodging apartments. So the Act sets out the rights and obligations of residential tenants and landlords in New South Wales, and also gives the New South Wales Civil and Administrative Tribunal, which is also known as NCAT, which I will refer to today as the Tribunal, power to hear and settle residential tenancy disputes in New South Wales. Okay. Okay, so common issues for tenants. The most common issues that tenants do face during their tenancies are obviously repairs, rental arrears and evictions, which obviously all have the ability to severely impact wellbeing of people, tenants in New South Wales. So in regards to repairs, tenants are obliged to actually keep the premises in a reasonably clean condition. They are also obligated to notify the landlord of any damage or disrepair as soon as possible so that it can be rectified. When a tenant vacates a property, there is an obligation for them to leave it in as near as possible to the condition that it was at the start of the tenancy, obviously with the exception of fair wear and tear. And tenants are also obliged not to damage or permit damage to the premises deliberately or negligently. Okay, so onto the landlord's obligation. So landlords also have obligations when it comes to repairs. They are obligated to provide the premises to be in a reasonably clean state and fit to live in, and must provide and maintain the premises in reasonable repair. What is reasonable actually depends on a few factors. So this is the age of the premises and potentially the rent that a tenant does pay. Landlords must also make repairs referred to in the original condition report, but we need to know that they are actually not responsible for repairing any damage caused by tenants. So what to do if a landlord won't do repairs? So tenants usually think that they should withhold rent to put pressure on landlords to make repairs, and I really need to highlight that it's important that tenants do keep paying their rent, because a rent strike is actually a breach of their tenancy agreement, and the landlord may actually take steps to end the tenancy regardless of any repair issues. So if a landlord or an agent cannot be contacted, or they are unwilling to do any urgent repairs, or if it's taking too long to do repairs, tenants can arrange for the repairs to be done themselves. Tenants should not pay any more than $1,000 because they may not get that money back. The landlord is actually only required to pay a tenant back for any reasonable costs up to $1,000. Noting that the landlords are actually obliged to pay this amount within 14 days of a notice. For tenants, for this, tenants have to be able to show that the problem was not their fault, that they made a reasonable attempt to contact the landlord or the agent, that the tenant gave them a reasonable chance to do the repairs. They also need to show that the repairs were carried out by a repair person who is named in the lease agreement, if there was somebody named in the lease agreement, or by a licensed or qualified tradesperson. Tenants must also give the landlord or the agent written notice about the repairs, costs and copies of any receipts. So if the landlord doesn't pay, the tenant can actually apply to the tribunal within 3 months from the end of that 14 days for an order. So if the tenant can't afford to pay the urgent repairs, which more often than not they can't, they do have an option to go to the tribunal for an urgent hearing to get the repairs completed. It's probably important to note here that this is when tenants can actually apply to the tribunal for a rent reduction until repairs are done, rather than going on that rent strike, which is really not advisable. Okay, rental arrears. So another common problem for tenants is rental arrears. Not paying rent is actually a breach of any tenancy agreement, and it can result in a landlord taking steps to end a tenancy. Rent must be paid for must be in arrears for 14 days or more before a landlord can actually issue a non-payment termination notice. So the tenancy can still be saved from a non-payment termination notice if the tenant pays the outstanding amount. There is an exception to this. So if the landlord is pursuing an order that the tenant has frequently failed to pay rent on time, then even if the tenant does pay the arrears and the tribunal makes a finding that the tenant has frequently failed to pay rent, then the tenancy may still be terminated by the tribunal. It's important to note that a termination notice does not actually end a tenancy. To end a tenancy, a landlord actually has to apply to the tribunal or NCAT for a termination notice. So if a tenant receives a termination notice, they really need to get some legal advice very quickly.
There's just a quick question in the chat. Sorry, I don't know if you can see the chat.
No, I've got to do a few things like taskbar.
Do you want me to read it to you?
Sure.
Jane's just asking if it costs the tenant to take the issues to the tribunal.
Okay. Generally, if the tenant is in receipt of a Centrelink benefit, there are concessions, but there may be a small cost involved. So the tribunal is very, very different to court in the sense of like filing fees are significantly less. But yeah, I mean, I'm happy to send around some fact sheets if you would like in regards to the fees and things like that, just so you have a little bit more information around that if you would like.
Yeah, that'd be helpful. Thank you.
Yeah, okay. Also to note, we as a legal service actually don't do tribunal representations, but there is the local tenancy advocacy service, Verto, who we do have a very good relationship with. So, you know, we liaise with them quite a lot, and Verto does do representations at the tribunal for clients. So if it's something that we can't assist with, if you do refer to us, we certainly can provide you with some referral pathways to get your clients some assistance. Okay. All right, so what to do if a tenant is in arrears? So the first thing we always advise is that a tenant should ask for a rent record to actually ensure that they are in arrears. If they are in arrears, tenants can either pay the outstanding amount or they can negotiate a payment arrangement. If the tenant is experiencing financial hardship, we would obviously refer them to a financial counsellor for any assistance. And if a tenant receives a non-payment termination notice, obviously, again, we would advise that they would get some legal advice. Okay. So in regards to evictions, so in most cases, landlords and their agents must give tenants a termination notice. The notice does actually have to meet certain requirements to be valid. So for example, it has to be in writing, it has to be signed by the landlord, it must set out the address, the date that they want vacant possession, and finally reasons for termination if there are any. There are minimum notice periods for termination notices. So for example, a no grounds termination notice has a minimum notice period of 90 days. If the property is not vacated by the date provided in the notice, the landlord can apply to the tribunal for a termination order. If a tenant does decide to stay in the property and doesn't vacate the property by the date listed on the termination order, the landlord will then have to go back to the tribunal and apply for what is known as a warrant for possession. And this is essentially where the sheriff comes, knocks on the door and actually removes the tenant from the property. Okay, so tenants' rights in regards to eviction. So landlords must follow a prescribed process before they can evict a tenant. They can't simply just lock a tenant out of a property without an order from the tribunal or the court giving them possession. So if the landlord or the agent acts to end a tenancy when a tenant tries to enforce their legal rights, such as asking for repairs to be done, the tribunal may find that the attempted eviction is retaliatory and may declare the termination order to have no effect and or refuse to make the termination order. Again, if a tenant is in this situation, they should seek legal advice about their options. So I'm just going to delve into the impacts of domestic violence in regards to tenancy. So the domestic violence tenancy provisions in New South Wales do allow for victims of domestic violence to enter tenancy early, and there are some criteria regarding this. So firstly, it does need to be established that there has been domestic violence in the household, and we'll talk a little bit more about what that looks like in a few minutes. Secondly, the victim is either a tenant or a co-tenant, which also includes a subtenant. Thirdly, does the victim want to leave? And fourthly, does the victim have relevant evidence? So evidence in this instance would be a copy of a certificate of conviction of a domestic violence related offence, a copy of an apprehended domestic violence order, whether that was interim or final, or potentially copies of Family Law Act injunctions. So if a tenant answers yes to all of the four criteria, a domestic violence termination notice attaching the relevant evidence can be served on the landlord or the agent and all other tenants who are in the property. So the tenant can then vacate the premises and keys can be given to the landlord or agent. It's obviously advisable that any tenants keep copies of everything in case the landlord later changes the validity of the termination. But generally, where a tenancy has been terminated due to domestic violence, a victim doesn't have to pay a break fee or compensation to the landlord for ending the tenancy early. So the victim will not be listed on a residential tenancy database, which these are very tricky, horrible things, which actually have the ability to blacklist people, which sort of precludes people from getting tenancies in the future. Any evidence that the victim has used must be handled confidentially. And finally, the victim may be protected from liability to pay for damage to the premises due to domestic violence. So changing the locks, normally tenants cannot change the locks without prior consent of the landlord or without a reasonable excuse. So in the case of domestic violence, if a tenant or an occupant is prohibited from entering the property by an ADVO, this is considered to be a reasonable excuse. So if the victim or tenant changes the locks, all they need to do is provide a copy of the keys to the landlord within 7 days. And at HRCLS, we can provide support, advice and assistance to people in these particular circumstances.
It's just asked in the chat,
yes.
sorry, in regards to the evidence, does it need to be a copy of the conviction or could it be something like a police report?
Yeah, I think there's no real, obviously they would like a copy of the conviction, but if you have an official police report, you would really hope that the landlord or the agent would be amiable to that. I guess what we would probably advise that if they do have, if they are connected in with like WDV CAS or a support service like the Women's Centre, you know, maybe going into the actual real estate with a support worker to sort of legitimise that, because, you know, people are not just going to go into a real estate agency and say, I want so-and-so out and this is the reason why. But I think a police report should suffice, but I think in regards to the act, it may not. So, yeah, I think it's sort of a yes and a no type of a question. You would hope that the real estates would take that seriously, but I think by law, it does have to be one of those prescribed methods. But I'm happy to, you know, look into that and get back to you if you would like.
I guess it goes back to the case by case, doesn't it? You know, as things come up, we know we can get in contact with you guys for specific advice.
Absolutely. Absolutely. We're always here. Okay, so, all right. So I know this is probably a slide many of you already know about, but I think it's probably relevant just for the tenancy side of stuff that we've just looked at, but also in regards to the debts and the loans matter that we will be looking for the final part of the presentation. So domestic violence is where one person behaves in a way that controls or dominates another person and causes fear for someone's safety and well-being. So it really is usually a pattern of abusive and controlling behaviour, which takes many forms. It happens in intimate, family or informal care relationships. So on the slide, we've listed behaviours which are domestic violence. So physical or sexual abuse. So this would consist of things like punching or hitting, choking, any physical assaults, threatening violence, forcing someone to participate in sexual acts, damaging someone's property, threatening to damage someone's property, or hurting or threatening to hurt or injure pets. The emotional or psychological abuse, so this would consist of stalking and repeated text messages, insulting comments, calling someone names, blackmailing, preventing contact with family and or friends, and controlling somebody's appearance. So economic abuse is what we're going to touch on with the loans and the debts. Is really all about denying, withholding, controlling or misusing money or property or threatening to do so. And coercive behaviour. So that's forcing, intimidating or manipulating a person to do things they didn't want to do. So for example, signing a contract or legal documents, which gives another person power and control over a victim's life. So it's obviously important to note that this list is not exhaustive. There are many more examples of domestic violence than what's been listed here today. Also noting that domestic violence extends to children being exposed to violence or property damage too. Okay. So domestic violence is the leading cause of death, illness and disability for women aged under 45. It's also well documented that domestic violence has a devastating impact on an individual's physical, mental and emotional health, which includes depression, shame, anger and even suicide. Nearly 1/3 of people in New South Wales seeking help from homelessness services say that domestic violence is an issue. A portion of victims use alcohol and other drugs to deal with their pain, and there are also physical health injuries and problems which may not get medically treated. So, impacts of domestic violence on debts and loans. So financial abuse is a form of domestic violence that involves financial control. It generally includes forcing someone to enter into debt, making all the key financial decisions in a relationship. It would be things like spending joint funds without the other person's knowledge or consent, using joint assets and debts to control someone, which could potentially prevent someone from leaving an abusive relationship. So economic abuse might be seen by a perpetrator demanding their partner take out a loan for which the victim will receive no benefit. Sometimes perpetrators are aware that a loan in their name wouldn't be approved, and therefore they use their partner to get access to credit they otherwise wouldn't be able to get. Generally, what we can see at HRCLS is, by ensuring that a transaction or a loan is in a victim's name, the perpetrator makes the victim entirely responsible for all repayments and all of the interest and the fees and the charges associated, which may even potentially affect their credit rating, which obviously we would deem to be just a further act of domestic violence. So at the service, we also see perpetrators of domestic violence using victims' credit cards or their buy now, pay later accounts without consent. Obviously, after the money's spent, the victim is then solely responsible to make repayments. We often see perpetrators demanding victims enter into consumer loans for household items. So, for example, we've seen where perpetrators wanted a new TV or a new fridge and have threatened a victim with forms of domestic violence if they didn't comply and do what they were told. So in 2015 and 2016, the Victorian Royal Commission into Family Violence made findings specific to the economic abuse that victims suffer, saying that they have received evidence that service providers, financial services and utility providers did not consistently and appropriately recognise, intervene and respond to economic abuse and the financial hardships associated with post-family violence separation, and that financial security and independence are significant factors in victims gaining freedom from violent relationships and also in their recovery. Also, an economic abuse reference group have detailed that family violence can have a significant detrimental impact on a woman's financial well-being, both during the violent relationship and when a woman leaves the perpetrator. Financial security being one reason a woman may stay in a violent relationship. So women who are subject to family violence are likely to experience significant financial detriment, often over long periods. Many of these women are subject to economic abuse from their partners, which has further worsened their financial situation, and also risks their ability to live independently. So Australian researchers have identified that economic abuse was present in up to 90% of cases presented to family violence services. And economic abuse is the most significant reason why a woman would remain in or return to a violent relationship. Okay. So what most people don't realise is that there might be an option for victims of domestic violence who have taken out a loan on behalf of their partner or who are now unable to make repayments due to domestic violence. So a victim is not automatically liable for their partner's debts, whether they are married or not. If a victim has signed a contract as a co-borrower or a guarantor, or was a director or partner in a small business, or as the recipient of a service, so that would be things like Foxtel or Netflix or whatever that might be, they may be liable for the debt. So if a victim has signed or entered into a loan contract, there may be some options available. So, for example, if the lender or the service provider knew of or facilitated duress, which are threats of force used by a partner to make someone sign, or if there were any red flags regarding undue influence. So an example of this would be when speaking with a lender, whether their partner was present and taking control of the conversation. This should be a red flag to a lender. But I think, like everything during COVID, it went from, going in person to get these loans to actually doing it on the phone, which potentially would make it more difficult for lenders to spot victims acting under duress. So another option might be a compassionate release of a debt based upon the lender's domestic violence policies and current personal circumstances, noting that currently banks and telecommunication companies, most of them have domestic violence and hardship policies. So there is scope for us to be able to help even in that instance. There also may be some legal defences, so unjust contract. So this is essentially where the legal and practical effects of the loan may not have been adequately explained, where someone has not been provided sufficient time to consider the full effect of the loan, whether someone was told that there were other alternatives available, whether there was time for somebody to obtain independent advice regarding the loan, whether the relative bargaining position of the parties was unequal. So, for example, where someone is unable to negotiate the terms of the contract. Another legal defence may be unsuitable loan, or what we would call responsible lending. So credit providers must make an assessment as to whether the loan is unsuitable before entering into a contract with a consumer. So in making an assessment, all credit providers must make reasonable inquiries of a consumer's requirements and objectives. So they need to actually sit down and think about, why is this person wanting this loan? What are they going to use it for? Because assessing a consumer's purpose for the loan, it has to be sufficiently specific and consistent with the amount of credit being sought. So for example, it's not okay to state on a loan application that a consumer wants a loan to do a training course when the consumer is illiterate or has a disability and is not actually capable of undertaking the course. So credit providers must also make reasonable inquiries into the consumer's financial situation, and they need to actually take reasonable steps to verify a consumer's financial situation. So when doing all of the checks and balances, the kind of information relevant would be the lenders need to check the amount and source of a consumer's income. They would need to look into their employment, the length and nature of their employment. They would need to look at a consumer's fixed expenses, whether there were any variable expenses. Does the consumer have any existing debt? What is the consumer's credit history? Whether the consumer had any assets, whether there are any reasonable foreseeable financial changes in the future, and whether a consumer has any indirect sources of income. So to meet these obligations, credit providers are required to make an assessment that consumers can actually afford to repay the loan without financial hardship. So another legal defence might be that a victim is signed up as a co-borrower when they're actually a guarantor. So a co-borrower is where you are jointly and severally liable for a debt and are responsible for the entire debt, including things like interest, default fees, enforcement. You're essentially liable for everything if the other person doesn't pay, which is very different to a guarantor who is responsible for the entire debt if the principal borrower doesn't pay. So you will be liable as a guarantor for interest, default fees, enforcement, etc., or up to the amount that has been guaranteed. So for larger loans, a guarantor will have to provide security, for example, over a home. So before signing as a guarantor, it generally is a requirement that independent legal advice is sought. And the purpose of this is so that the consumer understands the potential ramifications of being a guarantor, what entering into this kind of a binding enforceable agreement looks like. And if this hasn't happened, it may be that this person is in need of legal advice. Okay, so lastly, the final legal defence that we'll talk about today is the statute of limitations. Okay, so excuse me. So what a lot of people don't realise is that creditors or lenders can only pursue someone for 6 years from the date of the last payment being made or 6 years from an acknowledgement of debt. So generally what we can see is that when the 6-year time limitation is almost up, lenders are really cheeky. They begin to harass people and try to get them to make even a one-off small payment of $5, which would then give the lender another 6 years. So essentially, making that one-off payment triggers that time limitation to then start again, and they've got another 6 years to pursue a consumer for that amount of money. So community lawyers, like us at HRCLS, we can help. We offer free assistance if a victim is legally represented and the lender is aware of it. The lender is actually duty bound to only deal with us as a victim's lawyer. If an outcome isn't acceptable or it's not agreeable, victims do have the right to make complaints to relevant authorities such as the Australian Financial Complaints Authority, which is known as AFCA, and relevant ombudsmen. So that would be like the Energy and Water Ombudsman, Telecommunications Industry Ombudsman, all of which like we would assist with if we took on the client. So I guess what I can do here is we'll come back to questions in a minute. So this is just our contact page. So that's our address. We've got our phone number. The 1-800-918-377 is our office number. You can email us at cls@umfc.com.au. We do have a Twitter and a Facebook. All right, so let me just have that. I think you'll be able to have all of that information anyway. So what I might do is I might actually stop sharing the presentation and come back on screen so that we can sort of go through questions and things like that. I just need to know how to actually unshare. All right. Have I unshared successfully? All right, all good. Okay, any questions? Did you want to chat? I probably just do need to let you know that like we do secondary consults. So if you are a bit stumped by something, if you think it's something that our service may be able to assist you with, we're always happy to have a chat. You can email CLS, you can phone the 1-800 number, you can ask to speak with, you know, whoever is available. So just so you're aware, we're always open. And yeah, so the CLS email is a way that you can refer clients through to us, or you can just call, or a client can obviously call and make an appointment that way. So just so you are aware, we do give advice on all area of law except criminal and employment and wills and estate. So they are the 3 areas we don't give advice on. But anything else, yeah, like I said, we are a free legal advice service. Yeah, any questions?
Is that yes to me?
Yes, whoever.
Hey, yeah. So I've got a family that I'm working with. So she's actually has a mortgage in a house, and she left the relationship because there was, all sorts going on. But she's been out of the house for like a year, and he's stayed in the house, refused to leave. She's actually got legal advice, and has been going to court around it. But I'm just wondering how it works between the difference between tenancy and if somebody's actually got a mortgage.
Yeah, so this is obviously family law side of things. So in regards to mortgages and things, that would obviously have to be all part of a property settlement family law issue. So if she's already legally represented, we probably couldn't do anything in regards to that.
Sure. So. Yeah. But like what, say if it was early days, like where does the person, the DV victim, where have they got to stand when they've actually left to get away from the
so they
relationship?
They need to get some legal advice, preferably before they actually do leave. Because we would be able to then put them in contact with local support services. So generally in New South Wales, it would be WDV CAS, or it would be the Women's Centre, Betty's Place, those kinds of, support around them. Also to note, I think it's probably not widely known, but there is victim services in New South Wales. So that is like a compensation type scheme for victims of any type of violence, but you don't have to have reported an act of violence to police to be eligible for 22 sessions of counselling. So all you would need to do is fill out an application form and provide a government issued ID. And you would be eligible through Victim Services in New South Wales to have 22 free counselling sessions. So that's not your 10 Medicare that you get for free, which I think was bumped up to 20 because of COVID. But it's only if they have reported to the police, they could potentially be eligible for, security expenses, if there was damage to, clothing during the act of violence, things like recognition payments. So I'm not sure if you know too much about victim services, but it's actually a really good scheme. Obviously, like everything in life, it could be better, but we also do give advice on that as well, and can potentially sit with clients and help them with their application forms and sort of go through what sort of things they might need to look at if they want to, claim further counselling expenses or, security expenses like CCTV if they do have concerns for their safety.
So it might be worth her discussing that with her legal aid person.
Yeah, absolutely.
And see whether she can get something. Yeah, beautiful. Thank you. Is there any other thoughts, questions, queries? No.
Anything in general? I know it was quickly run through, but if you wanted to call and let us know, if you wanted us to go through anything in more detail, we'd be happy to do that. We do a lot of consumer law here at the legal service, and we do a lot of compassionate waivers based upon domestic violence. Like I said, most people are not aware that particularly the big banking institutions and a number of debt collectors, interestingly, do have domestic violence policies. So it may be just as simple as, us writing a letter saying this client, is in receipt of a Centrelink benefit, they're potentially at risk of homelessness, they're a victim of domestic violence, and asking for a compassionate waiver of, debts or loans, or if there's no issues like legal issues like irresponsible lending or the unjust contract. So it is more than one way to potentially look at getting debts waived. But yeah, even things like, arrears of electricity and, gas bills and things, which generally a lot of victims are lumped with if somebody leaves, and they can have, $2,000, $3,000, $4,000 bills, which they don't even know how they're going to pay. So I think it's a good step in the right direction for these particularly energy type companies to be developing domestic violence policies, but how they sort of navigate that is another question, I suppose. It's only until you try and help someone then you'll really see whether they mean what their policies say, I suppose. So.
Wonderful. Thank you so much for your time today. We really appreciate it. It's been good to hear some of this information. Renee, before we wrap up, did you have a question?
Yes, sorry. I'm just speaking on the arrears. I mean, I've got a client in a bit of a hairy situation with rental arrears as well as electricity and gas. Is it just for the electricity, like the utilities component, or can it be extended to rental arrears as well?
Rental arrears is a different kettle of fish. So any rental arrears are generally dealt with by the tribunal. It would obviously, we would be happy to have an appointment with your client. Obviously, if your client needs a support person, we're more than happy for, any of you to sort of be part of the conversation if that's what the client would feel receptive to being able to talk with us about that. But it's not as simple as just asking for that to sort of go away. It's different with electricity and gas. We can do that based upon domestic violence policies or, but it would really depend on if the matter was at the tribunal yet and then those kinds of issues. But happy to have an appointment. So if you just wanted to call our 1-800 number and book in if the client wanted to, we'd be more than happy to sort of have an appointment. So,
Right, thank you.
Now, I just did want to flag, we do have some more bite-sized law presentations coming up over the next few months. So we are putting together a buy now, pay later specific bite-sized law session. So I was talking with a financial counsellor who obviously the concern is that the younger generation are actually not getting credit cards anymore. They're using this buy now, pay later, and they're not really understanding the cons. They're all just looking at the pros of what it looks like. So we're going to put something like that together. That's at the end of the month. We're doing a fines session if you're interested, I think in March. And I think we're doing a motor vehicle accident sort of tricks and tips of, if you're going to buy from a, private seller versus that kind of stuff. So we do have a few things coming up. And because we are auspiced by Upper Murray Family Care, we do have a referral pathway for the financial counsellor. So if any of your clients are in financial hardship and you do think that they would benefit from some financial counselling to sort of work out a budget or, do whatever financial counsellors do, we can make that referral. Okay, so just so you're aware as well.
In regard to the upcoming sessions with the bite-sized law for the Intereach guys, I get sent all that detail. So as it comes through, I'll make sure to flick it out. And then for Mission, if you guys are interested, if you don't already receive updates, I know if you flick Simon Crace an email, he'd be more than happy to pop you on the distribution list. Was there any more questions?
Yes, Renee, do you have your hand up?
No, that was previously.
Oh.
I don't know how to
Long-standing
take it
hand
off.
up.
So
that's all good.
I'm not sure if you're joining us or who's doing the next lot of sessions, but I know we have a session on AVOs, I think on Wednesday, and then
so
we have.
Yeah, I think that's with Erin Quilliam, who is the family lawyer in New South Wales. So yeah, I think it'll be a great presentation. She's fantastic lawyer, and I think that you'll all really, really enjoy listening to her.
Beautiful. Thank you so much. Thanks so much for your time. We really appreciate it. And obviously we have now, or well, we had it before, but we've got them again, all your contact details to be able to reach out. It's always a nice
Yes.
refresher to know what services
Yep.
are available out there, so we can, you know, get the advice and support we need for, particularly for those of us working directly one-on-one with families. So
Yeah, absolutely. And thank you for all of the work that you do. I know that it's, you know, you're probably not thanked enough, but it's community workers who really do make the difference. We as lawyers just sort of come in at the end of things and, you know, do only a fraction of what you guys do. So thank you for all of your work you do locally. And I know I go out to Intereach at Corowa and out at Deniliquin, and everyone's really lovely. So thank you for the work you do. It's really great.
thank you. We appreciate it. Definitely.